technically the judgment must go because the appeal abated even before the judgment came.
So when the appeal was taken before the High Court,
Right. Just 3 days, Malas. Trial court decree is dated 15th March 2018. 15th March 2018 trial court decree in my favor. Their appeal, my lords, filed in 2018. He died on 21st October 2010. Appellant number 1 before the High Court. 20th October 2020.
20th October 2020.
And the impugned order is passed, reversing the decree in his favor, my lords, on 10th February 2023. My lords, after your lordship issued notice, my lords, in February 24, your lordships, officer of this court's officer report indicated when they tried serving them that he has passed away. So we applied, my lord, that's the delay. But technically the appeal abates. Respondent number 1's appeal in the High Court now abates.
But I am appearing for respondent number 3. So I still have to file my counter affidavit.
3 times they sought time, my lord, but nothing.
So far as this particular person is concerned,
With respect to respondent number 1, my lord, I have only instruction to say that because I am not appearing for respondent number 1. That's the problem.
but in any case, notice may have to go.
I'll also leave this question because I want to agitate this matter. I'll also leave this question open so that I can urge this. They are brothers, all of them, my lords.
What is the IA number?
Yes, IA number 128085. 128086, 88 and 90. 4 IAs.
These IAs have been filed on account of the passing away of the respondent of Anjaya, Utimbaga defendant number 1 on 20/10/2020. Stop. Mr. Permission, learned counsel would point out that the decree in favor of the 20 in the title suit 20 of 2010 was rendered on 15/3/2018. And although the defendant number 1 died on 20/10/2020, the High Court, by its judgment dated, by the interim judgment dated 10/3/2023, allowed the defendant to appeal and dismiss the suit filed by the petitioner. Stop. The High Court was unaware.
High Court was unaware.
The High Court was unaware about the death of the appellant at that point of time. Stop. The application, application for substitution of LR is also supported with other applications for setting aside the abetment and condemnation of delay, etc. Stop. Issue notice, returnable in 4 weeks. Stop. Which respondent?
Respondent number 3.
Mr. Frenson and counsel appears for the respondent number 3. You are defendant number 5.
I am defendant number 5, my lord.
Defendant 5. So the counsel pays for and is granted 4 weeks time to file response in the matter.
This is the third time in that issue. Third time they have sought time.
You granted them for the third time.
Yeah.
I am so glad.
Why you are not filing the
Lord, I will file
you
it.
will die or something? I mean, your client, I am not saying you. Yeah.
Lord, I will. Lord, this time we will file. Lord, it's a complex matter, and because some local council is also involved, who is going to assist us.
Just like that. You should not hear this kind of comments, right? About that.
Gather all instructions, please.
Direct for the appointment of,
Let me open
9,000.
He is not even a respondent.
9,000, I'm respondent 1. 9,533 candidates, which includes me. Now that was with a caveat there, the rider, that it should be stated in clear terms that the appointments made shall be subject to the outcome of the present petition. Now Mr. Patwale represents those.
So let me just open my case.
Allow me to complete my sentence.
My friend
I'm
has
just
said
saying I'm just saying that these 9533, their appointments can be confirmed. Mr. Patwalia's will be filled up against the latter half if they are successful before your lordship. If they are not, then it will be the others who are below us who will get appointed. But if ours can be properly confirmed without the rider, that would be helpful. That's my preliminary submission. That's all I have to say.
That will have to be heard.
Just, this is the whole object is to deflect the hearing on merits.
No.
Every time my friend does it.
Not every time before this court,
No.
ad hoc bench,
Yes.
please do not try to,
Yes.
this thing. We have other matters, so we are not going to take up this matter.
I have a very short request to do. Please see the last
To
one.
make the request, yes.
Yes.
No,
In the-
don't ask us to see it,
All
to
right.
make the request.
So, we are people who qualified during the period 20.
We make the request, Mr.
Just
Patwali.
one line and then the request, because it has to be placed before that. We are people who qualified in the period 20 to 22.
Yes.
There's no we are not eligible. Now, pre-20 are people who have all been appointed. 2,500 vacancies remain. Last time your lordship said, please declare our result and produce the list in court. So far the list is not produced. May I just read that one line order, my lord? That is 15th May 24 order. List, and we have also given the interview. List the matter on 23rd July 24 on the, this is the order of 15th May. List the matters on 23rd July. 15th May. 15th May. Board had already filed an affidavit in the first matter.
Somebody else is standing.
No, we have order is on the said date, in addition to the affidavit which has already been filed by the board, list of persons mentioned in paragraph 14E of the affidavit dated 21st March shall also be kept ready. These are those 20 to 22 batch. The court found in an earlier order of 29 January, 11,000 vacancies were advertised. The pre-2020 are 9,500. 2,500 vacancies remain. We are less than 2,500. We are 950 before your lordships. In all, about 2,500. All of us can be accommodated.
Not eligible.
If the board points out whether we are qualified and suitable, then all of us can be accommodated. That is what I am saying, and there will be no surviving lists. So at the moment we are only saying let this order be complied with. And
The order passed to that effect. It's
just kindly see the 29 January order.
Sir, and the orders and the complied with,
Just see the 29 January order for a minute. That will clarify the position. 29th January. Please see the 29 January order. 29/1/24. In fact, the order, this matter was argued for some length. Paras 2 to 4, 3 paras. I'll read it, all 4 paras. Once your lordship gets the 29 January order. My lord.
yes, it is there.
Can I just read it quickly? It's just 1.5 page. By the order dated 22nd January 2024, the respondent West Bengal Board of Primary Education was directed to file an affidavit furnishing certain details relating to candidates. The said affidavit has been filed with copies furnished to learned counsel for the parties. As per the affidavit, 11,758 posts in various different subjects in various categories in all districts across the state of West Bengal were advertised for the post of assistant teacher for primary classes. After furnishing the details of the number of candidates who had applied in response to the advertisement, it has been averred that as per the draft list prepared by the respondents, 9,533 candidates qualified. This excludes us, which includes an additional panel of 5% candidates in accordance with the rules. It is also stated that a total of 2108 D.El.Ed candidates have been found not to be qualified amongst the pre-2020 batch list. It is further stated that D.El.Ed candidates from 20 to 22 course have not been considered in the draft list due to the issue pending in the present matters. That is us. Having regard to the facts that as against 1178 posts in different subjects in various categories in all districts in the state of West Bengal, the respondents have found only 9,533 eligible candidates, including additional panel of 5%. It is deemed appropriate to permit the respondents to declare the merit list with a rider. It should be stated in clear terms that appointments made shall be subject to the outcome of the present petitions. The letters of appointment to be issued to the successful candidates shall also specifically state that their appointments will be subject to outcome of the present petition. My instructions are that a total of 9174 people have been appointed since. Now, para 4 is important for me to do. The board shall conduct final interview and candidates from the 20 to 2022 course, that is us, and submit a report within 6 weeks from today with copies furnished to the other side. The remaining posts shall be kept vacant and are made subject to further orders that may be passed. So this is that list which your lordship said produced. Now, in their affidavit which they have filed, I did not read it, but they have said that interviews have taken place, list of us.
Sir, you are considered to be non-eligible, non-qualified.
Yes, because the division bench judgment today stands against us.
So you can't be passing any directions of your appointment or consideration without going.
We are only saying, my lord, let us see how many of us have qualified, and then,
You don't know, and we don't want to know at this stage.
my lord, at one stage your lordship on the last date had said produce that list. But in any case, the issue is also very narrow. The issue is very, very narrow. I can address it now. Or your lordship, give us any convenient, when it is convenient, brother. I don't want to push myself.
May I make a prayer? May I make? There are some implement applications. Would you also consider issuing notice in them?
Yeah.
They can come up next day.
Yes, the implements are.
Without even getting a notice, is already contesting without realizing what I am praying for.
That one application, your lordship will reject it just now. Your lordship may read it's 1.5 page. I have not been able to make any sense of that application.
Very
Let us
I
smile
want to
once
become a petitioner.
The judges
Let us
do their.
smile once again.
I have said my bit, my lord. I have nothing to do.
The board has that list, my lord. If the list can be produced, we will know where we stand, my lord. Is our only request.
Do everything that is to be done when you take up the matter for hearing, not in this pattern, right? Yes. Since this bench is in a long bench, the matter which would require some hearing cannot be taken up as any other matters are awaited in consideration. So the matters can get up by 2 weeks. Yes.
Great. Yes, sir.
Your Lordship consider issuing notice in the implement applications.
Rejected.
Oh my Lord. That is
You
not.
have passed the order. After that, you are saying,
No, my Lord. I am so sorry. I thought.
you are pressing your application, so I am passed an order.
Lord, very sorry. I'm not. Please recall that order of rejection.
No, sorry. Yes, yes.
Lord, kindly recall that order.
Recall.
Not exactly. Kindly remove the order of rejection.
No, it's rejected.
Sorry, my Lord. It will not be there.
Leave with a smile. All right. Oh, no, there, rejected.
My lord, this is the matter, my lord.